Social Security Disability Appeals. How to make arguments to win your claim. Hi, I'm Mark Whitehead, a board-certified disability attorney and author of the disability help book, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. As a Social Security disability attorney, I work very hard to prepare my clients' cases for disability appeal hearings. Unfortunately, there are some things that I just can't know. Will the administrative law judge, or ALJ, say that there's past relevant work that you can do? Will they find that your work experience, your age, your education, and your residual functional capacity show that you're able to handle a number of different jobs? These are things that come up in steps 4 and 5 of the appeals process, and they just can't be predicted when putting your case together before the hearing. Because of this, experienced disability attorneys tend to follow the rule of 3. What's the rule of 3? Quite simply, the rule of 3 is a strategy that says it's wise for your lawyer to show up at the hearing with 3 arguments for each of the potential issues that may come up in step 4 or step 5. What are these potential issues? First, your past relevant work. Your lawyer should have arguments showing why specific jobs should not count as your past relevant work. Second, your ability to perform your past work in a competitive job market. You need to show that you wouldn't be able to do the job as it's actually or generally performed. Third, why can't you do other work, known as step 5 jobs? These are the other jobs that the judge may argue that you can do. You should have 3 arguments stating why you couldn't do them. Fourth, theories of disability. It's not enough to say you're disabled. Your representative should have 3 disability theories ready to argue for this as well. For example, Your Honor, my client is disabled under Medical Listing 1.04. He also meets Grid Rule 201.14. Alternatively, he's at a less than sedentary work capacity. Now this may sound like Greek, but the judge and any good Social Security lawyer knows what that means. Why the rule of 3? The shortest answer is that your lawyer just can't assume that the judge will agree with him based on a single reason. What if the judge isn't swayed? Or what if they have a counter-argument that nullifies that reason entirely? This is why it's so important to have an experienced attorney to support you at each step so that you'll have the best chance of winning your Social Security disability appeal. If you have more Social Security disability questions, check out my free ebook, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability issue. I'm Mark Whitehead. Thanks for watching.